Hi, I'm Brian Heidelberger, a partner with the law firm of Winston & Strawn in Chicago, here today with another mini advertising law lesson, how to keep your native advertising law compliant in light of the FTC's recent policy enforcement statement. But first, it's a new year and you're wondering, Brian, there's nothing new on the set. Well, you didn't notice, I did jack up that camera just another 2 more inches to cover that continually growing double chin. I hope you appreciate it. So what happened when we were all partying and enjoying our holiday? The FTC issued an enforcement policy statement regarding deceptively formatted advertisements, also known as native advertising. It is not the law, but it gives us the FTC's view on how it's going to enforce its law on unfair practices with respect to native advertising. There really isn't a definition out there of native advertising, but the FTC has given us their own advertising that matches the design, style, and behavior of the media in which it is disseminated. And they've told us, listen, native advertising can be in all different kinds of formats. Written narratives, videos, infographics, images, animations, in-game modules, social posts, search results, email, even playlists on streaming services and user-generated content. So they want to make it clear it's really anywhere that you guys are going to try to play as marketers. But they've given us an interesting list, things that they want to explicitly focus on. Those formats include consumer reviews, expert opinions, news or feature articles, product reviews, or something you style as an investigative report or intimate that there is scientific research behind it. Those things we want to be particularly careful with because the FTC has said that those things are very material. So what did the FTC say? What is its standard? Well, advertising messages that are not identifiable as advertisements are deceptive. And they're going to look at it from the perspective not of a majority of consumers, but of a reasonable consumer. They're going to scrutinize the entire piece of marketing, the formatting, the target audience, the message itself, any kind of disclosures that you may have. But wait, just because you have a disclosure does not mean that your ad is not deceptively formatted. The FTC wanted to make clear that you need to take all of these things into consideration and look at it from the perspective of a reasonable consumer in terms of what their takeaway is going to be. Interestingly, the FTC has told us that mere product placement without objective product claims aren't going to turn it into an advertisement, kind of like on TV when you see that Coke bottle on American Idol. That would not be considered an advertisement that requires prominent disclosure. But the FTC has also said when looking at that piece of marketing that you looking at it in context, if it's inherently obvious that it's an advertisement, then that's fine. There is no more disclosure that's necessary. They give us an example of an ad in a news feed that says come in and drive today. The FTC says something like that is clearly an advertisement, and so nothing more is really needed to be stated. So what about the disclosure? Because most of the time that's what we want to do. We want to post something saying sponsored or advertising or paid advertising and feel like that's going to take care of it. The FTC has said that a qualifying statement such as the ones I've mentioned do help to remedy the situation, but we need to make sure that that disclosure is sufficiently prominent. And in terms of prominence, we're talking of placement. Don't put it off to the side. We're talking about in terms of color. Don't make it white or gray shaded. Don't make it type size very small. All of those things are going to be very important as to whether your disclosure is communicated. It's not good enough that it's there. It needs for a reasonable consumer to be able to read it and understand that this thing that they're looking at is actually an advertisement. The FTC says it wants simple language. Things like paid advertising and advertisement are things that it has stated would be acceptable to be used. Don't get cute, because if people don't understand it, it's not going to be enough disclosure. The FTC has also made it very clear that if you've got a headline that looks like it's news but it's really an ad, disclosure in the body copy might not be enough because, again, people might just read the headline and not read the body copy. And the FTC has said specifically you can't have disclosure just on the click-through if you've got a headline that makes objective product claims or otherwise is an advertisement itself. The fact that you can click on it and then later find that it's an advertisement advertisement is not enough. The FTC wants a disclosure right there, or something like come in and test drive today that makes it inherently obvious that it's an advertisement. So I hope that's helpful for the new year. You can always see more mini advertising law lessons at youtube.com/Brian Heidelberger, or follow me on Twitter at Brian Heidelberger. And until next time, let's be careful out there.